if we're to believe the medical examiner on the stand. Deborah Blum is still with me here, and we were talking about the speed at which this case has moved along. This has not been a lengthy trial. It's been a case with a lot of witnesses, a lot of detail, but they've been working full days, which is something that maybe that's what makes it seem like a quick trial for those of us here at LawNewz, because we're used to these cases sometimes not meeting Tuesdays or not meeting Fridays. They moved right along, worked a solid 8-hour day each day to plow through this evidence.
Well, I really think for the jurors' sake, as well as for the prosecution, the defense attorney's sanity, it's much better when a trial goes straight through the full day and the full week, because I've tried many cases and I much prefer when you actually begin, even if you begin at 10 a.m. or even 11 a.m. and you have full days, it's a lot better than doing it Tuesday and Thursday or only part of a day, because that really does not provide for continuity. And I guess here that the prosecution's evidence is so strong that these people were brutally murdered that they didn't feel the need to belabor that point. They just made their point. They had the medical examiners testify to exactly what they needed to. I do think there was some leading that I heard while sitting here and listening to what they got out of the medical examiner, which I would have objected to as the defense attorney. But at the same time, it doesn't seem that the defense is contesting that these were vicious and heinous murders. Their whole strategy is that this young man, although he's in his early 20s, was so badly brutalized by his own father, like he did to these victims, that is why he was involved. He just simply could not stand up to his father, who had a tremendous pattern of abusing him, to not go along with the murder. Most likely they're going to have either him testify or somehow close with that he wasn't the one that committed these acts, that the father was absolutely responsible and that he was just present, and that his mere presence alone isn't enough.
While we were talking here, there was the standard motion to dismiss at this point. I've never seen them granted. It happened in a flash. I think it was 15 seconds. They must have figured they were going to lose that one.
Well, I certainly wasn't the defense attorney, because my trial orders of dismissal last for a very long time, often to the dismay of the judge. However, despite the judge not being happy with the length of my trial order of dismissal applications, I oftentimes have been successful in having them granted, because it is
right at the end of the state's case in chief?
Yes. Because a lot of times the prosecution, even in the light most favorable to them, has not proven all of what they are charging the defendant with. It doesn't mean that you have the whole case thrown out, but some of the counts just are not sufficient. And with the appropriate amount of research and the case law behind you, the judge should do the right thing and dismiss those.
So, yeah, the judge said, okay, no, we're going to keep moving on with this, which is not a surprise. It was very, very quiet, and Kathy Russin caught it on her end, because she must be in a soundproof room or something like that, because I didn't hear it. But not a surprise at that point. So, at this point, we'll have to wait and see what the defense is going to do. They start tomorrow. But we also have plenty of other big things going on tomorrow. We've got the O.J. Simpson parole hearing in Nevada, and we've been spending almost every waking moment here on the sidelines here at the LawNewz Network getting ready for where we're going to go with that. Dan Abrams, our founder, who is no stranger to the O.J. Simpson case, will be sitting in this slot during the hearing. Amy Dash will be here in the morning. I'll be here in the afternoon. We have the dream team of guests for you here at the LawNewz Network, including many of the key players in the trial. So you're going to want to stay here on LawNewz for the O.J. Simpson case tomorrow. And the thing that's been driving me up the wall with this, Deborah, is just how convoluted Nevada is when it comes to sentencing. I have a spreadsheet that is, I think, 7 or 8 lines long just to make sense of all of what's going on in this case, because we had 12 original charges. The jury found guilty across the board on all 12, but 11 and 12 were alternates to charges 5 and 6. So they get dropped out because the jury didn't drop them out on their own. They just went
Legally.
party line conviction here. So he was sentenced on charges 1 through 10, but then it just gets even more convoluted because the first charge was supposed to be a year in the county jail, which he ultimately, from what I can tell, served in prison because he was convicted on the other ones. So he served his sentence out on the first, second, third, and third charges in full. The second charge, they granted a full parole in 2013 and discharged it, but then this is where it gets even more complicated. Some of the charges, he was paroled in 2013, but then that charge moved into a second phase because there's an underlying charge, okay, of kidnapping and robbery that he served. He was paroled, but then there's an enhancer for a deadly weapon, and that has to be served separately from the original charge. And we've just been having a debate all afternoon. That is Beth Karras, again, no stranger to the OJ case, Rachel Stockman, our editor-in-chief, and myself, and whatnot, to try to figure out what's going on here. So the bottom line is he faces parole for this litany of deadly weapons charges that were all sort of rolled into one sentence just for administrative ease, thankfully. And then the assault charges is what it turns into. That boils it down about as clean as we can make it. Are you glad that you are not in a jurisdiction that handles sentencing in such a convoluted manner?
Well, sentencing can be very complex. Even here in New York State, you have timing issues with respect to your client having multiple open cases. There's a whole litany of issues that you face as a defense attorney that you have to make sure you do correctly on behalf of your client, or else your client can and will serve extra jail time, and to undo that is very difficult. So it's very crucial as a defense attorney to be familiar with all of the ins and outs of sentencing, and even if you're the most familiar with it, you could still make a mistake. So there's a lot at stake when you are a defense attorney and your client is serving jail time, and your job is to minimize that to the greatest degree possible. It sounds like OJ was a model inmate, so most likely he is going to be paroled. It also sounds like he had a lot of special privileges that most inmates do not have, including a flat screen TV. So I think that this is an interesting case. I have a feeling he will offend again. That's my own personal opinion, because although he wasn't convicted for the death of his ex-wife and her boyfriend, I think it was pretty clear that he committed that murder. And, he was part of a violent crime here. So now his funds are depleted. I'm really not sure what he's going to do other than most likely, again, reoffend.
Yeah, okay, so a lot of people are saying that the chances are strong for O.J. Simpson tomorrow that he would be granted parole. And there's this other mess that blew up. The Daily Mail ran this story that's got all these lurid details in it, claiming, some prison guard caught O.J. Simpson pleasuring himself in his jail cell, and that's a violation, and he might not get parole for it. But the parole board is telling LawNewz that that's fake news, that they don't know where the Daily Mail got this from, and that everything is rolling along as planned for a hearing tomorrow. So that's just another thing that was thrown into this at the last second, which led to a litany of Twitter storms and people just going nuts over what's actually going to happen tomorrow.
You've got to love the Daily Mail.
LawNewz is confirming that that is fake news. That is exactly what the parole board in Nevada told us, that they do not have a record of that being an issue. Check LawNewz.com for the full trajectory of that story today if you haven't checked it yet.
Well, it seems like from all the research I've done into this that OJ has been the model inmate, but it's also been really easy for him to be the model inmate, because I have clients who most likely were doing nothing wrong, but they'll get written up and then they'll have a strike against them or a few strikes against them. And it seems like the corrections officers were not going to punish OJ. In fact, it seems like they gave him a lot of special privileges, and it all makes sense that he has a perfectly clean record. The one thing that I do have to commend him for is that he does accept responsibility for his roles in these crimes, and that is something that the parole board is going to take into great consideration when they make their ultimate decision. Time and time again, you'll see people don't get their early release because they're not acknowledging their role in the crime, or they're not going to go along with what corrections recommends for them to do, the programs that they have in the jail, and OJ did complete everything that was asked of him. So those all do support him being released.
Yeah, I mean, look, this is not a time for people to try to dip all the way back to the California murder case. Like, that thing was settled. It was an acquittal. If people don't like it, okay. You know, this is not the time to bring that up. This is Nevada. This is a separate thing. This is a question of whether he paid his debt to society in Nevada for that litany of charges that he faced there. This is not the time to relitigate what happened to Ron Goldman and Nicole Brown Simpson.
Well, it seems like the state of Nevada is certainly not looking to do that, and the prosecutor who prosecuted this matter is not going to, from what I've read, be present at the hearing, which means that the state is not opposing his release. So that's another really strong reason. It doesn't seem like the individual victims who were the victims of this crime are going to testify against OJ and say, no, you must continue to stay in jail. So it really seems like all signs are pointing to him being released. And I hope that during his period of post-release supervision that he is under a tight leash, for lack of a better word, so they can make sure and put him on the right path to ensure that he doesn't reoffend.
Yeah, so that's coming up tomorrow with the OJ case. But we also had a verdict today in the YURICH case out of Ohio that we were following, and I feel somewhat vindicated in my analysis, because it turned out that my analysis was pretty close to spot on, that the judge found that there just wasn't enough evidence after the blood alcohol and the urine samples got thrown out for not being refrigerated. After that, there just wasn't enough to make a drunk driving or an operating while impaired charge stick. So losing those labs was fatal to the prosecution's case, and ultimately, because they lost them, they didn't get the felonies. They wound up with 2 misdemeanors. Good defense lawyering. I can see you beaming at the thought of the skill of the defense lawyer in that case, because 2 misdemeanors probably won't affect the doctor's medical license at all.
Absolutely. I don't believe that his medical degree will be taken away from him, although from my understanding of most professions, whether you're a CPA, a doctor, an attorney, a misdemeanor conviction can have you lose your ability to practice, but it's not an absolute bar. So he's going to have to go through the appropriate hearings with the medical board to determine whether he's still going to be able to practice. Most likely he will be able to. Maybe he'll face some kind of penalty. Maybe he'll have a period of time where he's not able to practice medicine. We will wait and see on that. But, you know, a lot of times there is police error, and also highlighting the fact here that the police officer who testified, or at least one who testified, said that initially he wasn't displaying signs of intoxication. This simply could have been an extremely tragic mistake where he was driving too quickly, and he was not steering his boat properly, and that's what led to the accident. It might not have been due to his intoxication.
Yeah, so, you know, an interesting case there. Interesting legally, you know, the local press is reporting that the blood alcohol level was a .152. You know, but if it wasn't refrigerated, it doesn't get into the trial. So the issue there is with the police who testified at the evidence hearing that they didn't even know that it had to be refrigerated. Well, that's on them. If the doc truly was a .152, he walks.
I think that
the burden is on the state, is in other words what I'm saying.
Right. Well, the prosecution has the burden of proof, and they have to properly get in their evidence. And with a blood and alcohol sample, there are certain procedures that need to be followed. And I commend the judge in that case for telling the prosecution, you did not do your job, so you will not be able to rely on that evidence. It's very unfortunate that there's a loss of life. There's no way around that. a terrible tragedy. However, the police oftentimes make mistakes, and sometimes the judges will allow for those mistakes, but our system of justice dictates that they shouldn't. So the appropriate thing happened here. I would find it hard to believe that he was a .152, especially if you have police testimony saying that he wasn't showing signs of intoxication. And around a .10, I would say it's possible you're not going to show a sign of intoxication, but a .15 is close to double the legal limit in the state of New York, so you would be showing signs of intoxication. And his wife said that he wasn't, and
the police said he wasn't either. But the one thing that struck me as kind of wiggy in that case is this testimony that at least the people he was around were drinking Red Bull energy drinks or Monster energy drinks. One of the energy drinks, I think it was Monster. And we've heard testimony in other cases that those energy drinks can cancel out the effects of alcohol. So someone could be intoxicated in their mind, but they would not be showing it outwardly because the stimulants in the energy drinks kind of negate or cancel out the depressive effects of the alcohol. So, they didn't go that far in the case.
Right.
I think the prosecution should have dived into that a little bit more. They didn't. They had the doc on the stand. If I was prosecuting the case, I would have said, you said that he had energy drinks. Did you drink any Monster? Did you drink any Red Bull? And if there was a yes out of there, I would have then had to go and rebut that somehow with an additional witness, even on behalf of the prosecution, because that might have accounted for what was going on, if we're to believe the BACs.
But they might not have been able to due to the preclusion of the use of the BAC. So that might not have, the judge might not have allowed for that type of testimony.
Well, they couldn't get the BAC in, but they could get in evidence that he was potentially, this is hypothetically, if he hypothetically consumed energy drinks, and an expert was willing to say that the energy drinks would have canceled out the outward signs of intoxication, it would have deflated the argument that he didn't look intoxicated and therefore was not impaired.
Well, I think that that's what it highlights the difference between having a